Hello everyone. So today's video is for the CMA Inter students, and in today's video I'm going to discuss in your Institute's material. They have given a few set of questions. So today I'm going to discuss the true and false of Companies Act with you. So let's start with it. The company shall not convert its existing equity shares with voting rights into equity share capital carrying differential voting rights. Yes, yes, and vice versa. Yes, company can issue, but they cannot convert. This is true. Board of directors is not required to disclose in the board's report about the issue of equity shares with differential. They have to disclose. This is false. They have to disclose. The holders of equity shares with differential rights shall have the right of getting bonus. Yes, they rank pari passu with the equity shares, equity shareholders. So it is their duty. It is the company has to give them the same rights as any other equity shareholders. A company can issue shares at a discount. No. Other than sweat equity or conversion of debts, company can never issue shares at a discount. Securities premium can be utilized for the purchase of its own shares of securities. Yes, there are five purposes for which it can be utilized, and one of it is for purchase of its own shares. Others are issue of fully paid up bonus shares, then right of preliminary expenses, premium on redemption of preference shares, also right of discount or commission on issue of shares or debentures. No reduction of capital shall be made by a company if it is in arrears of repayment of any deposits excepted true. If company has not repaid its deposits, it cannot go for reduction of capital. Company limited by shares or limited by guarantee and having a share capital may by ordinary resolution reduce. No. Reduction of capital can be done only by passing a special resolution. Alteration can be done by ordinary, but not reduction. So this is false. The cancellation of shares shall not be deemed to be reduction of share capital. Yes, cancellation or diminution of share capital is considered as alteration, not reduction. Where dividend is not paid to the preference shareholders for a period of 3 years or more, they shall have a right to vote. This is false because it's 2 years or more. If the dividend is not paid for 2 years or more, then they will have a right to vote on every matter. Bonus shares shall be issued by capitalizing reserves, created by revaluation of assets. No. Whenever we issue bonus shares, it can be issued out of free reserve, securities premium, and CRR. It can never be issued out of capitalization of revaluation reserve. Where there is no company secretary, the annual return shall be signed by yes, true. It has to be signed by a practicing company secretary. Then annual return filed by the listed company shall be certified by a practicing. Yes, true. Annual return is not required to be attached. This is false because it has to be attached with the board's report. Copies of annual return may be furnished to any member or other person on payment of fees subject to a maximum. This is false because maximum is 10 rupees, not 5 rupees. Annual return shall be prima facie evidence of any matter directed or authorized to be inserted therein by or under this act. True. A general meeting may be called after giving a shorter notice if consent is given in writing by not less than 50%. False. We need the consent of 95%. Only when the consent of 95% is given, then we can call the meeting by a shorter notice. Notice of every meeting of the company shall be given to the auditor of the company. True. He has a right to receive notice under section 101. Under section 146, he does not have a right to speak, but if any matter concerns him, he can speak. The articles of the company shall provide. Now, see, there are two ways of looking at it. If they would have given may provide for the quorum, this would have been true. But shall provide is not mandatory. If the company wants, they can give a higher number as a quorum, but it's not mandatory. If the quorum is not there within half an hour in a meeting called by the requisitionist, the meeting shall stand adjourned to the false. Because when the meeting is called by the requisitionist and the quorum is not present, the meeting stands adjourned, dissolved. I'm so sorry. A member of a company not having a share capital is entitled to appoint a proxy. No, a member of a company not having a share capital cannot appoint a proxy. President of India may appoint such person as he thinks fit to act as his representative at any meeting of the company. True. And he will become member personally present. A demand for poll may be withdrawn at any time by the person who has made a demand. True. E-voting shall remain open for not less than 3 days and shall close at 5 p.m. on the date preceding the date of the general meeting. True. Once the resolution is cast by the member by e-voting, he is again allowed to vote no. He can attend the meeting, but he cannot vote at the meeting. OPC and other companies having up to 200 members are not required to transact any business through postal ballot. True. They don't have to conduct postal ballot. Company may appoint more than 15 directors after passing a resolution. This is true, but actually it is not. When you say resolution, it's ordinary resolution. But they can only appoint by passing a special resolution, not by passing a special ordinary resolution. All companies know false. All companies are not required to appoint a woman director. An independent director shall not be entitled to stock option. True. Whole-time director is not the employee. Stock option schemes are not given to independent directors. Whole-time director is not the employee of the company. False. He is an executive director. He is the whole-time employee of the company. I mean, he's the employee of the company. This is false. Additional director shall hold office up to the date of the next AGM. True. Once he is appointed, till the next AGM, he shall continue to hold the office. The din allotted to a director before the commencement of this act shall be deemed to be the din true. Allotted true. If a person has already obtained din under the old act, he does not have to renew or get a new din. Non-obtaining of din does not amount to disqualification. This is false because it is a disqualification of a director. The board may accept the resignation of a director on his submission of his application for resignation. Yes, the board has a right to accept resignation of a director. The removed director shall not be reappointed. True. Once a director is removed, he will not be reappointed. In any financial year, if a company has no profits or its profits are inadequate, the company shall not pay over. They have to pay remuneration, right? They have to pay remuneration. If just because there is a loss doesn't mean you will not you will not pay remuneration to the directors. So I hope you are learning, you are studying. Happy learning and stay motivated. Thank you so much.